Hello and welcome. Welcome to all of the participants here at Harvard and in the wider world. My name is Gerald Newman. I'm a professor of international law and the director of the Human Rights Program here at Harvard Law School. We're here today to talk about the resurgence of child labor in the United States and the rights of the child. Many of us saw news coverage last spring about shocking increases in child labor in the United States, but also about legislative efforts to undermine regulation of child labor in various states. And not only local efforts, but efforts that are part of a concentrated campaign to roll back protections. Now, clearly, this is not the only human rights problem in the world today that deserves attention, but it is one that is occurring very close to home and is our responsibility. And we think it is very important for us to talk about it, which is why we've convened this panel today. For the United States, children working in factories sounds like a bad part of old history. In the 19th century and in the early 20th century, in fact, many students still learn about it in constitutional law, how the Supreme Court of the Lochner era struck down attempts by Congress to regulate child labor. And then after the New Deal, the modern court upheld those efforts to regulate. Harvard actually played a negative role in this story in the 1920s, but I won't go into that now. The exploitation of child labor is not only a policy problem for the United States and a moral problem, but it raises questions of international human rights law. International labor conventions address child labor, including ILO Convention 182 on the worst forms of child labor, to which the United States is a party. Article 24 of the Covenant on Civil and Political Rights, to which the United States is also a party, guarantees every child the measures of protection required by their status as a minor. And this is understood as addressing child labor, among other issues. The Convention on the Rights of the Child has more explicit provisions on regulation of child labor. Now, the United States is the only UN member state that has not ratified the Convention on the Rights of the Child. But the United States has ratified the optional protocol to the Convention on the Rights of the Child on the sale of children. And the United States has obligations under that treaty that overlap with prohibitions of economic exploitation and trafficking of children. This legal sketch that I've given explains the choice of leading experts who will be exploring those issues with us today. In the order in which they'll be speaking, first, Terry Gerstein directs the State and Local Enforcement Project at the Harvard Center for Labor and a Just Economy. She's also a senior fellow at the Economic Policy Institute and a former Open Society Foundation's Leadership in Government Fellow. Previously, she worked for over 17 years enforcing labor laws, including as the Labor Bureau Chief in the New York State Attorney General's Office and as a Deputy Commissioner in New York State's Department of Labor. Benjamin Smith is the Senior Child Labor Specialist of the International Labor Organization, the ILO, where he supports member states in the development and implementation of policies and programs to tackle child labor. He previously served as a Presidential Management Fellow with the United States Department of Labor's International Bureau of Labor Affairs. Benyam David Mesmore is Professor of Law at the University of the Western Cape in South Africa, and he is a member of the United Nations Committee on the Rights of the Child, which monitors compliance with the Convention on the Rights of the Child and its protocols. He served also as the Special Rapporteur on Children in Armed Conflict of the African Committee of Experts on the Rights and Welfare of the Child, and was recently an Eleanor Roosevelt Visiting Fellow here at the Human Rights Program. After the three panelists have spoken, there should be time for questions from the audience. And you can use the Q&A function on Zoom to submit questions. I will try to ask as many of them as time allows. Later, after a bit of delay for processing, the recording of this event will be posted on the Human Rights Program's YouTube channel and promoted through the Human Rights Program's newsletter. Finally, I'd like to give thanks to the co-sponsors of this event, the Harvard Union of Clerical and Technical Workers, the Harvard Center for Labor and a Just Economy, and the Harvard Law School Youth Advocacy and Policy Lab. With that, let's get the exploration underway. I give the word to Ms. Gerste.
Thank you. And I'm going to share my screen because I have a PowerPoint that I'll be sharing. And thank you for the opportunity to talk about this today. My own background is domestic, and so my presentation is going to focus on these issues from a domestic, U.S., federal, and state perspective. So first off, I thought it would be useful to give a brief summary of U.S. child labor laws in a nutshell. There are two main prohibitions at the federal level and in most states. One is that minors cannot be assigned to do hazardous work. There's a set of occupations under federal law, state laws that sometimes identify certain workplaces as particularly hazardous, and sometimes it's based on the job, but it's a prohibition against children being required to do work that is dangerous. And then there are also prohibitions on hours, the time of day, so that minors aren't working the night shift, and the total number of hours they can work. At the state level, in a number of states, there are also requirements that minors have to obtain work certificates, and employers have to confirm those. And that allows students, teachers, and the employer and the government all to know that that minor is working. In terms of enforcement, a few key points. One is that it's all government enforcement. There is no private right of action. There are really modest civil monetary penalties. At the federal level, the penalties are about $15,000. They max out in the $15,000 range. And there has been discussion among advocacy groups about the need to raise those. At the state level, they're often significantly lower than that. For example, in New York City, where I live and where I worked, the civil monetary penalty for a first violation is $1,000, $2,000 for a second, and $3,000 for a third and subsequent. In some states, the penalties are like $100. In one state, it's $20. So the monetary penalties are really grossly insufficient to deter violations. There are some other tools that can be used. For example, the Fair Labor Standards Act, the federal minimum wage law that contains our child labor provisions, has a hot goods provision that allows the Department of Labor to seek an injunction against the transport of goods that were produced in violation of child labor laws. And that is something that the U.S. Department of Labor has been using recently. And then a final point is that there is not federal preemption of state laws. The Fair Labor Standards Act is a floor, not a ceiling. So states are able to be free to be more protective or less, or not have any laws on this at all. We have seen in recent years a real surge in child labor violations that I think has been pretty shocking to most of us. The U.S. Department of Labor has had a 69% increase over the past 5 years. There's been media coverage in the New York Times of teenagers, 14 and 15 years old, working in meatpacking plants and construction sites, in food processing facilities, packaging Cheerios and more. Reuters did an investigation and found children as young as 14 working in an auto supply manufacturer that was working for Hyundai. The Boston Globe has found minors working in fish processing plants. and more. And there have also been high-profile cases by the federal labor department and state labor departments. The federal case that has gotten the most attention involves meatpacking plants for Tyson and JBS and other huge multinational meat companies, that they were using a subcontractor, PSSI, Packer Sanitation, to do the cleaning and sanitizing, including on the night shift. And PSSI was hiring minors through use of staffing agencies. But there have also been child labor violations, for example, in fast food restaurants. Chipotle had extensive violations of the hours requirements and has paid about $9 million in penalties based on investigations by the Massachusetts, New Jersey, and DC Attorney General's offices. Many of these cases, especially the worst, most egregious ones, involve immigrant children, but not all of them do. There are certainly cases, there are certainly cases where, like the Chipotle case, like some workplace injury or fatality cases that have involved minors who were born in the US. And then meanwhile, we're seeing some conservative states rolling back or attempting to roll back child labor laws. Arkansas removed the requirement of an employment certificate. Iowa passed a very confusing law that is going to put minors at risk by, in certain instances, allowing more prohibited work. Now, to understand why this is happening, it's useful to look at the overall context. And part of the context I want to share, my background is in labor, is that there's a high rate of violations overall in workplaces in the US. This is not just child labor. And there are tons of numbers and statistics I could share, but in the interest of time, I'll just note that these violations include violations of minimum wage laws, workplace safety and health, discrimination. When workers try to organize and form a union, they are frequently retaliated against and fired, and there are violations of the law. And in fact, workers who try to exercise their rights are often retaliated against. So in terms of the context, there are many, many different ways to frame the context. There's the context of immigration law. There's the context of the, hollowing out of human services agencies. There's the context of US foreign policy in Central America. I'm going to talk about the context in terms of labor and employment law and developments in relation to the workplace. And I'm going to talk about 3 trends that have been going on for decades that really set the stage for this to happen. One is the decline in union density in the US. Another is underfunded enforcement agencies. And the third is the so-called fissuring of the workplace. And with all of these, if we had higher union density, if we had robust enforcement, if we had lead corporations actually taking responsible for workers who are on their job sites doing work on their products, these kinds of violations would be much less likely to happen. So the first trend, the decline in union density, in the 1950s, around a third of the private sector workforce was unionized, and now it's about 6%. In surveys, about 50% say they would like to be. And this results from several factors. One, people have written whole books about this, but basically the National Labor Relations Act is too weak and is often violated. What does this have to do with child labor? When there's a union on a job site, there's an on-site monitor of the union steward or representative who sees what's going on. Unions empower workers to report violations without fearing retaliation. Oops, sorry, I went forward a page. Also, unions, sorry about that. Also, unions play a really important role in relation to, as political actors. They lobby for stronger laws. They also lobby and push for more enforcement resources. The second major trend I want to talk about is inadequate enforcement funding. The U.S. Department of Labor Wage and Hour Division enforces the child labor laws, but also minimum wage, overtime, Family and Medical Leave Act, a number of other laws. About a year ago, they had around 800 investigators for the entire country, which is around 400 fewer than in the late 1970s, and is really insufficient for addressing the needs. The OSHA, the Occupational Safety and Health Administration, has about 900 inspectors, and that is enough to investigate each workplace once every 190 years. State enforcers also have similarly pinched resources. A Politico study found that 7 have 0 wage and hour investigators, and over 30 have fewer than 10. And then there's the fissured workplace. This is a term used to describe corporations that are avoiding directly employing people who perform core elements of the work, and instead they use business models that insulate them from having an employment relationship. Contracting, subcontracting, outshoring, using staffing agencies or temp agencies. And this leads to more violations and worse working conditions. At the top of the chain in the lead corporations, you have large multinationals that are more organized and above board, that have general counsel, they have an HR, they have profit margins. When you go down to the bottom of the chain, you have smaller, less organized entities with fewer resources. And each layer in a supply chain or in the fissured model has to make some profit or take a cut, which leads some to cut corners. It's much harder to enforce the law in a fissured structure. In the US, there is a concept of joint employment, but it's very hard. It's not impossible, but it is like threading a very difficult needle to actually get joint employment status. The Fair Labor Standards Act defines employ as to suffer or permit to work, which is a very broad definition, but the case law has really narrowed that and looked much more carefully at the exact relationship between that worker and that employer and who's supervising and who's paying. And so some of these major cases that have come to light have occurred in fissured workplaces. PSSI, there were the major meatpacking corporations that hired PSSI, and then PSSI used staffing agencies to hire the teenagers. Also, there were the New York Times story talked about teenagers working in a Cheerios processing plant. It's a similar situation there. So the lead corporations are really insulated from responsibility for the workers. At the same time, they're the entity with the real ability to prevent violations. They can do more due diligence before they subcontract. They can monitor conditions. They can make compliance a material term of the contract, with consequences like we will break the contract right away if you violate the law. And they can also take the work in-house. It is not a law of nature that all corporations have to constantly subcontract. And in the case the USDOL brought, JBS, the meatpacking company, actually opened its own sanitation and cleaning unit, directly hiring the employees to do this work, and had a contract, now has a contract with UFCW, with a union. So these jobs, which were being done by teenagers, totally unsafe, inappropriate jobs for kids, are now being done by union workers. So now I'm just going to go very quickly through some laws or policies that could help in this area. Some of them are, real possibilities. Some of them maybe, are a little bit more thought exercise. But one point that I always try to emphasize talking in the US is that the federal government is not the only avenue, and that states can take a lot of action, and localities in some cases too. So one law that would really help is facilitating more unionization and updating our National Labor Relations Act. There's a law in Congress, the PRO Act, that would do this, and that would eliminate many of the barriers. More enforcement resources sort of goes without explanation. It's very clear that we need resources among enforcers to do this work. Greater civil monetary penalties. Many people are focusing on this, but I'll just note, if we have higher penalties alone without more enforcement, the penalties are less relevant because people won't think they have much of a chance of being caught. And then we need easier ways to hold lead corporations liable for violations in their supply chains. There are some laws to this effect at the state level in relation to construction, for example, where the general contractor is liable for violations by subs, and they can later seek indemnification from the subs if there are violations. Another thing that I have thought of is, the lead corporations often say, well, we had no way of knowing this was happening. So perhaps you could have a scenario where for a second or subsequent child labor violation in their supply chain, they would have strict liability because with the first violation, they're already on notice. Workers' comp policies are also a lever for deterring violations. In the US, there's a grand bargain of workers' compensation that workers can't file a tort lawsuit for damages, and in exchange, they get the certainty of having workers' comp insurance. There are some states that allow tort lawsuits if a minor is injured while child labor laws are being violated. The deterrent value of this is that it massively increases employers' potential exposure and consequences if they violate the law. Publicity is something also that can help. There was a study by a Duke professor of OSHA press releases, and he found that they significantly deterred safety and health violations by peer employers in the same industry and geographic region. New Jersey Department of Labor this year they passed a law that creates a wall of shame where they list violators publicly. Procurement is also another tool. The basic concept that government contracting dollars should not go to businesses that flout labor laws. There are a number of local governments that have passed wage theft ordinances that create contracting consequences for violators, so the locality won't contract with them. And there's also a bill to this effect in the Senate in relation to the U.S. Department of Agriculture. Requiring work permits for minors in any states that don't provide them. I think sometimes those states that have removed them, like Arkansas, it seemed like a technicality or burdensome, but this is an example of the Massachusetts application for a work permit for a minor. And you can see that the employer has to include the minor's job title, primary duties, the number of hours. And the application itself has a summary of all of the child labor laws on it. And a number of states, I've looked at Hawaii and Oklahoma and Washington State, Massachusetts, the work permit applications do play an educational purpose. Mandating workers' rights education would be another useful tool. Most adults don't know their rights at work. I think people are expected to learn it by osmosis. But California just passed a law designating a specific week as workplace, readiness week, and they're adding to the high school curriculum training about child labor, wage and hour, workplace safety, union rights, and other basic labor laws. And then several other policies I'll just highlight. One would be to create a private right of action. So it's not just the government that can enforce the law, and that would expand the pool of enforcers. A whistleblower right of action could help as well. There were certainly coworkers who saw these violations happening and didn't have any avenue or job protection didn't feel they had job protection for reporting them. Liquidated or compensatory damages for minors. Right now, when there's enforcement, the only thing that happens to a minor is they lose that job that they and their family need for income. But if there were some kind of damages, that would be helpful. And then there are certain immigration-related policies that could really help. The nonprofit KIND, Kids in Need of Defense, has been arguing for a right to counsel for unaccompanied minors in immigration cases. If they had a counsel, that person would obviously be possibly someone who could spot these violations. And if minors had work authorization, if immigrant children had a more ready path to work authorization, they could get above board jobs with employers who are not violating all of these laws, because our child labor laws do allow children over 14 to actually work. They just place the very modest and sensible safeguards that I mentioned at the beginning. My final thought, if we want to stop child labor in the United States, we really have to value both children and labor a lot more than we do. But at the same time, there are a lot of opportunities for positive action. So with that, I will stop and turn to our next speaker.
Thank you for that foundational description of the legal framework and the situation on the ground in the United States. Mr. Smith.
Thank you. Thank you. Good afternoon to everyone, and big thanks to Harvard Law School for the invitation to be a part of this panel. It's a real pleasure for me. Just by way of a brief introduction to the ILO, we are the UN agency for the world of work. Our mission is social justice, and we're the only tripartite UN agency, meaning that governments, workers, and employers have a seat on our board and the governance structure. So the ILO sets and monitors international labor standards and provides technical assistance to support our member states to implement them. Now, the elimination of child labor is one of the fundamental principles and rights at work, and has been on the agenda of the ILO from the beginning, from its founding in 1919. So during the time that I have the floor, I'd like to do three things. First, set the scene globally and say a few words on the size and nature of the problem worldwide. And then I'll speak about vulnerabilities globally that are relevant to the situation in the US. And then finally, I'll review what the ILO's supervisory bodies that monitor compliance with our conventions have said about the situation in the United States. So in 2020, we registered the first increase in child labor since we began measuring it 20 years before. Today, there are 160 million children engaged in child labor, almost 1 in 10 children worldwide. Half of them, 79 million, are in hazardous work that puts their health, safety, and moral development in danger. In Asia and the Pacific, and in Latin America and the Caribbean regions, we've seen progress, and child labor continued to fall even in this most recent period from 2016 to 2020. We take a snapshot typically every 4 years of the global situation. However, in that period in Africa, child labor rose by 20 million, a 27% increase since 2016. And that increase is made up entirely of very young children, so between the ages of 5 and 11. Now, an additional 9 million children were at risk of being pushed into child labor by the end of 2022 as a result of the COVID-19 pandemic. But this is not something that we need to resign ourselves to this outcome. The pandemic, in fact, confirmed what evidence had already demonstrated: the direct and dramatic impact, in many cases, of increased social protection on child poverty rates, and by extension, on preventing and eliminating child labor. And United States was one of those countries where this was proven, just clear as a bell. Okay, so in terms of sectoral distribution, 70% of child labor is in agriculture. So tens of millions of family farms that are functionally dependent on child labor to operate. 20% is in services, and that includes 4.5%, which is children in domestic work, and that's mostly girls who are involved in that. And then 10% is in industry. So it's really a rural phenomenon. Largely, its child labor rates in rural areas are 3 times higher than in urban areas. Most takes place within the families, about 72%. So family-based child labor, whether family farms or family micro enterprises, is frequently hazardous. And this is despite common perceptions that working within the family provides protection and that it's somehow safer than work elsewhere. Now, child labor is by no means restricted to low-income countries, and this is the rationale for the panel today. Most child labor, children in child labor live in middle-income countries where pockets of poverty and social, economic, and cultural marginalization of certain groups oftentimes play a role. So to give you a couple of examples, in Peru, child labor amongst indigenous children is almost 3 times higher than the average. And in Ecuador, indigenous children are 12 times more likely to be involved in hazardous work. In Guatemala, indigenous children reported that discrimination and marginalization by teachers and peers prompted them to drop out of school and to look for work elsewhere. So I mentioned that child labor is a fundamental principle and right at work. so is non-discrimination, and the links between those two are clear. Other fundamental labor rights include freedom of association and collective bargaining. So I really appreciated Terry's highlighting that link where workplaces are organized, you don't find child labor. And then, of course, you have occupational safety and health and no forced labor as the other fundamental rights. And countries, even if they don't ratify the conventions that underline those principles, are still obligated to report on them because they are fundamental labor rights and by virtue of their membership in the ILO. Another vulnerable group is migrant children, often without proper travel documents, which makes them easy targets for exploitation or extortion. But of course, even though they lack papers, they are not illegal because people can never be illegal. While they may not have access to safe and regular migration, they don't leave their rights at the border, including their right to be free of child labor. So border crossings, transport hubs, bus stations, railway stations, airports, those are recognized points of risk for trafficking. And when children travel without their parents, it's very obvious that they're much more vulnerable to harm and exploitation at all stages of migration. Some children indenture themselves into debt bondage situations in order to raise enough money to migrate. And evidence shows that child migrants often experience maltreatment, including isolation, violence, substandard working conditions, non-payment of wages, and the threat of being reported to authorities. Migrant children receive less pay, work longer hours, attend school less often, and face higher death rates at work in comparison to local children who are in child labor. So just to be clear, child labor affects many, many more children than forced labor. So I wanted to kind of make that distinction between child labor and the subset, which is child trafficking. So 160 million child laborers. There are about 3.3 million children in forced labor. So to get the right policy response, it's really important to rely on international standards and definitions to understand the difference and apply that in law, and to rely also on a solid evidence-based data to avoid conflating those two. So I'd like to turn now to what the ILO supervisory bodies have said about the situation in the US. As was noted, the US has ratified ILO Convention 182 on the worst forms of child labor. So their reports are scrutinized by our supervisory mechanism, in particular, an independent committee of experts. And they found in 2020 that the Fair Labor Standards Act, and had found that previously as well, does permit children age 16 years and above to undertake in the agricultural sector occupations that have been declared to be hazardous or detrimental to their health or well-being by the Secretary of Labor. So this is an issue because the Convention 182 and the ILO's other convention on child labor, which is not ratified by the US, Convention 138 on minimum age, say that generally 18 is the minimum age for hazardous work. So the committee also noted that according to the Occupational Safety and Health Administration, OSHA, agriculture ranked amongst the most dangerous industries. It was the sector with both the highest fatality numbers, 389 deaths from 1994 to 2013 for all youth under 18, and amongst the age range of 15 to 17 was that sector had the highest fatality rate. The committee of experts also cited U.S. Government Accountability Office report which found that 5.5% of working children worked on farms, agriculture was responsible for more than half of child occupational deaths. So between 2003 and 2016, 237 children died in farm-related work accidents in the US, and that is 4 times the number of deaths of any other sector. The committee also, in addition to kind of calling out gaps in the application of standards, also recognizes progress and commends member states when progress does happen. And in the case of the US, it took note of measures taken by the government to protect health and safety of young workers in agriculture. One real, I think, important example was in 2017, when the government prohibited children from under 18 from handling agricultural pesticides, one of the key, obviously, hazards that can affect children's development throughout the course of their life, exposure to pesticides. With regard to trafficking, things like the reauthorization of the Trafficking Victims Protection Act was noted, as well as hundreds of child trafficking victims rescued and thousands of criminal arrests and convictions. However, the committee has repeatedly expressed concern that a significant number of children under 18 still suffer injuries, some serious, while engaged in farm work. Moreover, the statistical information shows that agriculture remains the most dangerous sector for children. The highest number of fatal injuries, especially for those who work for family-owned businesses or perform work that's not covered by child labor regulations. Now, since one of the things that I'm doing in my time is to kind of set the global framework, I think it's important to say a word about the role of the U.S. in the global and the worldwide fight against child labor. So since 2000, even counting the recent increase, child labor has dropped by 86 million. So really remarkable progress. ILO Convention 182 has achieved universal ratification. So this is a historic first, and a huge number of countries have put in place policies and programs to prevent and address child labor. So the U.S. has played a vital role in this as a development partner, supporting other countries, including through the ILO's international program on the elimination of child labor in every region, supporting data gathering, policy development, and direct action to tackle child labor. So wanted to end on that note, and over to you, Jerry. Thanks a lot.
Thank you. It's always nice to have a little good news in these human rights discussions. Professor Mesmer.
Thank you very much. I joined the previous speakers. It's an absolute pleasure to be here. So thank you for having me. On the point of good news, so I plan to go around my inputs in 3 phases. First, I want to put in a disclaimer, and then I'll say a few good news in terms of the substantive framework, and I will come to the not so good news, which I will reflect in relation to the US. In terms of the disclaimer, I have the privilege to serve on the UN Committee on the Rights of the Child. I've had the opportunity to be a rapporteur when the US government came to the committee reporting under the optional protocol on sale, child prostitution, pornography, but also the optional protocol on children in armed conflict. And those are very useful conversations. In fact, because the US is not a state party to the UN Convention on the Rights of the Child, that's our only opportunity to engage the government of the US. So whatever I say here, obviously, I'm not speaking on behalf of the committee. And secondly, the US government has actually submitted its 5th report under the 2 optional protocols, and probably in the coming year or a year and a half, the government will be scheduled for review. So whatever I say here is not a pre-review of that report. And as you will see, I will actually anchor most of my comments in relation to the previous review. Now, the good news is the Convention on the Rights of the Child is actually a very solid instrument. It's actually helped us to address a number of child rights issues, including the issue of child labor. As Benjamin rightly highlighted, there has been significant progress, and particularly Article 32, which talks about the fact that states recognize the right of the child to be protected from economic exploitation and from performing any work that is likely to be hazardous or to interfere with the child's education. This is important, to interfere with the child's education or to be harmful to the child's health or physical, mental, spiritual, moral, or social development. That has been a very, very important provision. And following that requirement of state parties to the convention, states have to provide, give regard to the relevant provisions of other international instruments. And we already made mention of the ILO Convention 182 and 138. States are also required under the Convention on the Rights of the Child to provide a minimum age or minimum ages for admission to employment. They have to regulate the hours and conditions of employment. They have to provide appropriate penalties. When Terry was mentioning some of those penalties that are actually being provided, I was cringing because they are penalties, but they're not appropriate penalties or sanctions that actually meet the gravity of the offenses that are actually being committed. But that's in connection with the Convention on the Rights of the Child, and the US is not a state party to the Convention on the Rights of the Child. So we have used the provisions of the Convention on the Rights of the Child with countries that are lowering minimum ages. Bolivia, for example, comes to mind. For instance, in their code, they allowed for children and adolescents aged 10 to 14 years to work in self-employment, which we took issue with. They also allowed in their law for children and adolescents aged 12 to 14 years to work for a third party, which we also had some challenge with, and so forth, so forth. So the convention has helped us to push the boundaries, but in the context of the US government, it's not going to help us much because the US is not a state party to the convention. Now, having said that, we have had occasions as the Committee on the Rights of the Child in 2016, 2017, even in subsequent years, where there is a push by different civil society organizations. The questions like what works for working children is asked. Or we have received letters that have been signed by hundreds of academicians and so forth, asking the committee to take a position to lower the minimum age. They view child participation and children's voices to almost be not just only the critical, but the ultimate deciding criteria in lowering minimum ages. And as a committee, we've actually pushed back. And our position is very much aligned with what the position of the ILO is. Now, the optional protocol on child prostitution and child pornography is of some help, without a doubt, because the US has ratified it, but also because there are some important provisions. For instance, Article 2 talks about the fact that for the purpose of the protocol, sale of children means any act or transaction whereby a child is transferred by any person or group of persons to another for remuneration or any other consideration. It plays a bit of a role in addressing child labor, forced labor. Article 3, which actually says, as a minimum, the acts that are provided in the protocol should be covered under its criminal or penal law, whether such offenses are committed domestically or transnationally or on an individual or organized basis. And in fact, when it talks about sale of children and the fact that criminal law and penal law needs to have that in its content, it says sale of children as defined in Article 2, offering, delivering, or accepting by whatever means a child for the purpose of sexual exploitation of the child, transfer of organs, but under C, it says engagement of the child in forced labor. So that has been actually a very important entry point for us in our engagement with the US. Now, it goes further than that, actually. It talks about criminalizing attempt, complicity. It also tries to provide that the penalties that are provided are appropriate, not the minimal ones that were mentioned earlier. It also says that subject to the provisions of its national law, each state party shall take measures where appropriate to establish the liability of legal persons or for offenses established in the protocol. So that is absolutely important because legal persons, companies, and so forth need to be held accountable, but there is also room for criminal, civil, or administrative accountability. So it's in a broader sense. Now, let me move to the US context, which is the not so good news. As was already mentioned, the US is the only guilty exception as far as ratification of the optional protocol, as far as ratification of the Convention on the Rights of the Child is concerned. And our engagement as the Committee on the Rights of the Child is very much based on the optional protocol on sale, child prostitution, and pornography. It has its advantages, but it also has significant limitations. Now, when the US prepares these reports, In fact, it provides that it draws from expertise from different stakeholders within the government. For instance, the Department of State, without a doubt, education, justice, health and human services, homeland security, interior, but also labor, treasury, as well as the U.S. Agency for International Development, USAID, and the Office of the U.S. Trade Representative. The last 3 or 4 that I mentioned are actually absolutely critical for our engagement when we speak to the government of the U.S., particularly in the context of child labor. Now, child labor does not always neatly fit into the optional protocol, but as the committee, we try to do our level-based. Now, let me mention a couple of limitations. First of all, almost always in its engagement with the Committee on the Rights of the Child, the US government provides, and I quote, "In the spirit of cooperation, the United States is providing as much information as possible in response to the committee's questions and comments, even in the instances where the questions or information provided in response do not bear directly on obligations arising under the optional protocol on sale, child prostitution, and child pornography." So in a way, it's a very polite way in which the government is pushing back, saying that even if we provide you some of this information, we do not necessarily consider it to be our obligation under the optional protocol. So it's very much in the spirit of cooperation that they're actually doing it. That's one. Secondly, because the convention is not ratified, the best interest of the child is not included as an obligation in US government, particularly in our engagement on child labor. So that's an important element to keep in mind. Despite all these limitations, when the US government came to the Committee on the Rights of the Child in the last round, 2016-2017, we identified a number of issues that speak very well to some of the interventions that were made by Benjamin and by Terry. For instance, as a committee, we expressed concern that the state parties' legislation concerning trafficking, including the Justice for Victims of Trafficking Act and the Trafficking Victims Protection Act, address mainly trafficking for sexual purposes. And it actually does not adequately address the issue of trafficking for the purpose of economic exploitation. In fact, some of the information that we had gathered in that review said that in many cases, legislation concerning trafficking focuses exclusively on sex trafficking to the detriment of many other issues, particularly child labor trafficking victims. For example, the Preventing Sex Trafficking and Protecting Families Act of 2014 and the Justice for Victims of Trafficking Act do not address child labor trafficking, and the US government's tendency to treat the trafficking of adults and children as being indistinguishable and to focus efforts primarily on sex trafficking has actually had significant repercussions on data collection, on law enforcement, and some of the limitations that we've just heard. The other issue we identified was the burden of proof of force, fraud, or coercion under legislation against trafficking purpose imposes heavy evidential burden on the victims of child labor. In many instances, these children are actually coming from communities that are ostracized, that are migrants, and so forth. So this threshold of force, fraud, or coercion as burden of proof was identified by the committee as being a significant limitation. Now, the other point we also highlighted to the government is the insufficient regulation of the working conditions of children aged 14 and 15 years in agriculture, which was already highlighted. And in that regard, one of the main points that was highlighted during that review is that the absence of the requirement for parental consent in this circumstance has actually led to grave violations of the rights of children, which we drew the attention of the state party. Another issue that we spent some time on is the wage and hour division of the Department of Labor tasked with identifying unlawful labor practices was reportedly under-resourced. And as the committee, we felt that it did not prioritize the prevention of child labor, partly because of resource limitations. There were also concerns about the fact that the efforts to identify child victims of trafficking for economic exploitation were limited, in part due to the fact that training of the professionals who come in contact with such children was found to be wanting. Now, let me mention a couple of points before I close. Lack of data on child victims of trafficking remains to be a significant challenge. The government of the US actually concedes. They say that it remains to be an issue. They have tried to establish a unified national data collection system, which involves a significant challenge for the United States because the federal government and state, territorial, tribal, local governments all have jurisdiction in this area, and data collection is done by all authorities, some of whom actually use different data systems and different definitions of offenses. For us as a committee to track progress, to track the impact of some of the interventions that are being made, to even identify the magnitude of the problem that we are talking about, which is the issue of child labor. Data collection is very important, and it's not just only data collection, but disaggregated data collection that we're very much interested in. Now, what the US does often has significant implications for other parts of the world. And the point about international cooperation, the role that the US plays, not just only financially, but in a whole range of other capacities, has helped to address the issue of child labor, including the worst forms of child labor. So what the US does at the domestic level often has significant implications outside, but also what the US does internationally has significant implications for issues of child labor. And I'll just single out one in relation to children in armed conflict. We have the enactment of the Child Soldiers Prevention Act of 2008, one of the two instruments that is aimed at implementing the optional protocol on children in armed conflict. And the US prohibits the provision of several categories of US military assistance to governments that directly recruit or use children. However, there is an exception to this. And this exception whereby the US president has the authority to grant full or partial so-called national interest waivers. In fact, for instance, in 2013 and 2017, we saw as the committee that such waivers were granted to countries that were recruiting children, that were in violation of the provisions of the optional protocol. So one can easily juxtapose this to the conversation that we're having about child labor. Quite a number of the efforts that the government of the US does will have significant implications, not just only domestically, but also outside of the US. So the ratification of the Convention on the Rights of the Child, even though it's not a silver bullet, it's not an idea whose time has come. It's an idea whose time is long overdue in coming. And secondly, the full and detailed implementation of the optional protocol on sale, child prostitution, and child pornography will help us to push the boundaries for the realization of children's rights, particularly those that are victims of child labor, but also for the purpose of prevention. Let me stop here. Thank you.
Thank you. I'd like to turn to the questions from the audience for a moment. The one question related to making available this webinar after it's over, and I just want to repeat what I said earlier, that it will take some time for the technological processing, but that this webinar will be available on the Human Rights Program's YouTube channel, and that publicity for it will also be in the newsletter of the Human Rights Program. The other question was actually, that I've received, is actually related to the point that Benyam was making just at the end about US ratification of the rights of the child. It asks, why is it that the United States has not ratified the rights of the child? I'll turn that to the panel in a moment, but first I'd just like to say a couple of things about that. One is that part of the issues may relate to questions of US federalism, in a sense that the subject matter of the Convention of the Rights of the Child often deals with things that are issues of state law rather than federal law, and that it's difficult to get support in the United States for that degree of increase in federal authority. Another is concerns about the degree to which the Convention on the Rights of the Child could be understood as interfering with legitimate parental rights. And here I want to go back actually to what I said earlier about Harvard's negative role in the 1920s. President Lowell of Harvard actually played a significant role in defeating the ratification of a constitutional amendment that Congress had proposed to the states that would have authorized Congress to deal with the issues of child labor. And part of the argument there was that prohibiting child labor would interfere with legitimate rights of parents. That led to the rejection of ratification in a referendum in Massachusetts, and the fact that Massachusetts, which had been viewed as a liberal proponent of this reform, rejected ratification, then led to the collapse of the ratification effort in the 1920s. So Harvard has a lot to make up for here, as in certain other areas. But this question of to what extent is this a parental rights issue? To what extent are parental decisions that children should work? To what extent are family employment legitimate issues of parental rights? That's something that members of the panel may want to discuss in this connection also. Benyam, should I go back to you first about the ratification of the convention by the United States?
Yeah, sure. Thank you very much, Jay. You have rightly addressed the main reasons that we have heard why the US is not a state party to the convention. As it is to be recalled, it was actually the Clinton administration that signed the convention in February 1995, but they did not submit it to the Senate primarily because of a strong opposition from several members of Congress. Now, there have been few efforts further down the line. In fact, during the election of President Obama in 2008, there was some refocus and attention about the possibility of US ratification, but subsequently that also didn't pull through. Now, some of the concerns about federal, local arguments, parental rights arguments, I have heard arguments pertaining to corporal punishment in particular, which there has been resistance to. The convention does not explicitly talk about corporal punishment, but there is Article 19, which has been interpreted by the Committee on the Rights of the Child as prohibiting corporal punishment. So that's one issue. Issues about sovereignty have been raised. The right to health care, the right to the highest attainable standard of health has also been highlighted as one reason. Now, let me just add a personal anecdote. In 2016, when I became chair of the Committee on the Rights of the Child, one of the things that I thought was I should actually try to engage with the US government to see the possibility of ratification of the instrument. So I set up an appointment with the then ambassador in Geneva, and we had a conversation. But the feedback that I received was that at that stage, the Convention on the Rights of Persons with Disabilities was actually not ratified. There was an effort to get it ratified, but the political atmosphere was not great. So the feeling that I received as a feedback from the ambassador was that the political environment was not the right one. So it was not really worth pushing. We tried to engage with different stakeholders to see if that assessment was right. And the feeling was that it was actually the right assessment. So we still remain with the only guilty exception, which is the US that's not a state party to the Convention on the Rights of the Child.
I can add a comment in response to your question about parental rights in relation to the recent rollbacks, because the recent rollbacks in Arkansas removed the requirement of a work permit, and it was framed as sort of removing government bureaucracy and, sort of a lot of kind of culture war framing of the government as bad, and we want to, get the government out of decisions that are between a child and the parents and the family. But in fact, the Arkansas, the work permit requirement did require the minor to actually get the parent's signature in order to show permission for the minor to be working. And so it's interesting when you look at this particular example, it just really demonstrates the way that kind of the political rhetoric that is behind all of this really doesn't match up with the actual substance of what is happening. So, there are all kinds of really wild parental rights moments now in relation to school curricula and really in conservative states in the US, and parents' rights are being manipulated in a very concerning way. But in this particular case, I think it's noteworthy that if you are a parent who actually really wants to be sure that you know what your teenager is doing, they just passed a law that makes it harder for a parent to do that.
Maybe I will zoom out a little bit and on this point on parental attitudes and pushback on child labor. So one thing that can be an obstacle in eliminating child labor is the cultural acceptance, the view that children work, it's a natural part of their upbringing, it's a way they learn important values and so on. And there, I think it's important to come back to what child labor is and what it isn't. I mean, it's not household chores. There's nothing about children helping around the house that's prohibited, and can be, that can be positive. I think anyone would recognize that. But in some regions, and I'm thinking particularly in Africa and West Africa, where we had pushback from even governments saying, because children helping out is such a part of children's upbringing, that they will help out in the household, and sometimes the household is the same thing as the small family farm. So we received a delegation from the government of Ivory Coast in Geneva to talk this out, and we went through the provisions of the conventions. They've ratified both of our child labor conventions, and the end result was that they concluded that there was no contradiction between what the conventions say and what they were trying to achieve in terms of not abolishing any activity on the part of children. So what they ended up doing was making light work available. So this is under Convention 138, a possibility to lower the minimum age from 2 years below the general minimum age. So as long as that work doesn't interfere with school, is not hazardous in any way, and is kind of limited in hours and so on. And so I think that oftentimes it's a question of understanding what child labor is and what child labor isn't, and the flexibility actually that is allowed under international law that can help resolve those sorts of those sorts of perceived conflict with cultural values.
If I could just piggyback on that, that is something when I've been speaking in the US context, one thing I always emphasize is that US laws and state laws do allow minors over 14 to work. They just have these very sensible restrictions on really hazardous work and on the hours of labor. And so to the extent that there's, comments about, well, the kids are just sitting on their beds, like scrolling through their phones, or, that this is going to teach them to have a good work ethic and get people career ready. Children are able to do that, but just within the confines of jobs that don't put them at risk or their education's at risk. And I think that in the policy discussions, it's really important to and valuable to kind of scope out that it's, in the same way that you were just describing, Benjamin, that there are ways that children can get, in many different contexts, that children can get the kind of work experience that don't create the real dangers that we're all concerned about.
Thank you. And thanks to all of the panelists. This brings us to the end of our allotted time. I think I just want to say in closing that there are many difficult human rights problems in the world, some of which would be very difficult to solve. Preserving existing legal protections against child labor in the United States and making sure that there's adequate funding for their enforcement would seem to be one of the easier problems. And I hope that the outrage that was sparked last spring by the news accounts continues to spark interest in preventing these rollbacks from occurring. Thank you all for being here, and thanks to our panelists.
Thank you very much.
Thank you.